risk of sounding Machiavellian, and I guess this is a parallel track that I have going on in my head all the time. I want very much to be seen as genuine. I want to be genuine and talk to people as individuals and respect them as human beings. On the other hand, as a lawyer, I know I don't want to be a sheep going to the wolves. I don't want to send sheep to the wolves. So I think that my studies in cognitive science, and I audited more than 30 hours of graduate level courses at Washington University over the past couple of decades. I think that not only myself, but John and Alicia take themselves to be students of human nature and to go into these situations where we're trying to persuade and make sure that we're using the best approaches that we can think of to persuade. So if for instance, in the old school, perhaps in law school, I think this is how I was taught. You look up the law and you decide what the cases say, and then you argue the cases to the court, and you say that this case should be decided like the old cases. I don't think that's the most effective way to deal with most cases. There's some cases, that's true. If you have a simple breach of contract, you might ask, is there an offer? Is there an acceptance? Is there a consideration? And if so, maybe everything falls in line, the stars align, and then there's no dispute about the case. But in the cases that we handle, which tend to be more complex, they deal with situations where you have to characterize what really is going on. Maybe it's not as clear as whether there's an offer or there's acceptance. Maybe we have to decide whether there's something unfair that went on. And then we have to decide what law applies or how laws conflict with each other. And it quickly can become muddy. Many times our opponents will grasp onto that and urge the court that this is a very difficult situation that doesn't lend itself to a judicial resolution. Well, what our job is to, as I see it more and more as I've gotten more experience, is that we need to find the best way to present the facts. Because I think that when a court or a juror hears the facts without us trying to spin it wildly or argue or pound the table, I think that the injustice of the situation becomes palpable to them. And so whether it be talking to a juror, and again, or a judge, I think we really want to tell the story in a way where we are seen as a trustworthy source of information. That's number one. We don't want to overstate the case, but we want to present the case in a way that is best understood and clearly understood and easily understood. Once we do that, if we are successful, we find that the court or the jurors take it from there, and they will help us find a way to resolve the case in a way that's fair. So I think that's something that's changed over the years for me. That's the way we write our briefs, whether it be in the trial court, whether it be in the Court of Appeals. I think we really strive to be seen as a trustworthy presenter of the case in a way that even our opponents would hear and think, that's a reasonable way to describe this case.